हाँ जी दोस्तों, क्या हाल है, क्या हाल है, क्या हाल है। आई होप यू आर ऑल डूइंग रियली रियली वेल दोस्तों। वेलकम टू द गोट रिविजन, द ग्रेटेस्ट ऑफ ऑल टाइम। यस गाइस, टुडे one second. Oh, perfect. All right, guys. So, welcome to the GOAT revision. In this revision series, we are doing chapter wise revision for each and every chapter of your CA intermediate law, as well as other subjects also. Let me tell you that you can find the chapter wise organized playlist on my channel, Shubham Singhal, as well as Ram Harsha sir's channel. You just have to go to the playlist section and you can find chapter wise revision of each and every chapter. First, we are doing the important chapters, and then slowly and gradually we will move to the smaller chapters as well. Okay. I hope the audio video is clear and everything is all right. Okay. All right, sir. This is going to be in 100% English. For those who are who understand Hindi, there is a separate rapid revision which you can go and watch if you want to enjoy in Hindi. But for those who have some challenges with Hindi, it is a 100% English revision. Okay, guys. So we are going to start a brand new chapter, management and administration. Before I start, there is one more point that I want to tell you. That one point is that if you are looking for a good notes for your CA intermediate law, then this is your one-stop solution. So these books of law has been summarized in just 200 pages. So if in 200 pages, there is 100% coverage of ICI module, and it is very color coded and very well organized for you to read it easily. So if you are looking for a book, then this is your go-to solution, and we are just, selling it for our cost. So you can go to the link in the description and you can go and order those books so that the hard copies reaches you on time and you have a very good experience. All right, guys. Thank you so much. Chalo, we'll start this chapter, which is management and administration. Listen to me very carefully. I need your 100% attention. Sir, this chapter begins from section number section number 88 to section number 122. Today we are going to do some sections starting from section number 96 to as many as we could, maybe till 106. We will keep it short and then we will take it forward in the next session. Okay, guys, what is section number 88? Listen to me very carefully. Sorry, section number 96. Come to section number 96 straight away. What is section number 96? Section number 96 talks about annual general meeting. Section number 96 talks about annual general meeting, a very important section. Sir, annual general meeting has to be conducted by every company. Every company has to take annual general meeting. When, sir? Sir, there are technically three time limits. One, it has to be taken each year. That is, you take the annual general meeting every year. Number two, sir, it should be the maximum gap between two annual general meetings should not be more than 15 months. So between two meetings, the maximum gap should be 15 months. And the third one is that the first AGM has to be held within 9 months from the end of financial year. And the subsequent AGMs can be held within 6 months from the end of financial year. So basically, there are three time limits. AGM has to be held each year. Number two, the gap between two AGMs should be maximum 15 years. Number three, the first AGM has to happen within 9 months from the closing of financial year. And the subsequent AGM should happen within 6 months from the closing of the financial year. Now, you can remove this particular line, sir. Listen to me very carefully. Sir, what if the AGM could not be held on time? So you said hold the AGM within 6 months from the close of financial year. What if I could not hold AGM at that time? Sir, if there is some special reason, then in that case, ROC may give you an extension. Or in case of special reason, ROC may give you an extension of up to 3 months, sir. Up to 3 months. You can get an extension of up to 3 months. But however, listen to me very carefully. Sir, if that extension is only for subsequent AGM, there is no extension in case of your first AGM. In case of first AGM, you will not get any extension. So basically, sir, if your company is incorporated, let's say on 1st April 2026 or 2025, when will you hold the first AGM, sir? Sir, your year will end on 31st March 2026 and the first AGM will be held within 9 months, that is 31st December 2026. What about subsequent AGM, sir? Subsequent AGM means AGM for the year 26-27 will be held by 30th September 2027. But if you could not hold it for any reason, then you may apply to ROC and ROC may give you extension of up to 3 months. But that is only for whom, sir? That is only for your subsequent AGM. It is not for your first AGM. For first AGM, you will have to conduct it by 31st December 2026. There is no extension. Now, after that, the next question is, sir, okay, we understood when to conduct AGM. Sir, but what is the time, place, what else? Sir, the time is you can conduct AGM on any day. except national holiday. Sir, you cannot conduct it on a national holiday. What is national holiday, sir? 15th, 2nd October, 15th August, 26th January. These are the only national holidays. So apart from that, you can conduct on any day. But what will be the timing, sir? Sir, the AGM which shall be called during business hours, that is 9 a.m. to 6 p.m. That is, sir, between 9 a.m. to 6 p.m. In the morning, 9 a.m. to evening 6 p.m., you will have to call for the AGM. Sir, I called for an AGM at 5:30 p.m. and it continued till 2 a.m. in the night. Is it okay? Is it okay if I call at 5:30 p.m. and I take it till 2 a.m. in the night? Is it okay? The answer is, as per law, there is no problem. As per law, there is no problem. We are only saying that the meeting has to start between 9 a.m. to 6 p.m. Now, it doesn't matter when it ends. You decide, your shareholders will decide. But for us, 9 a.m. to 6 p.m. Now, sir, what will be the place of AGM? So we said that it should be held either at the registered office or within the local limits of city, town, village where registered office is situated. Within the city, town, village itself. But listen to me very carefully. In case of an unlisted company, we said that unlisted company can hold it at any place in India. They don't have to conduct it in the registered office. They can hold it in any place in India. Only one condition. You have to take consent of all the members in advance. You can even go to Goa, but you'll have to take consent of all the members in advance. Only then you can conduct your AGM. Are you with me? Guys, are you with me? Yes, sir. You will have to take consent of all the members in advance. Like before the meeting, you have to take a consent for unlisted company. And what about government companies, sir? Government company can take it in the registered office or within the city or any other place as approved by CG. CG may decide any other place. This is for government companies. But this is the provision of annual general meeting and which is very frequently asked in your exam. This is the best part of this book, sir. Your all the concepts are linked to the question bank. So you can just go to the question bank and you can check these questions and you'll be done with this section completely. But now, what did I tell you? I told you that section, as per section 96, this is how you will conduct your AGM. Is that clear, sir? Yes, sir. Now, what about section 97 and 98? Sir, section 97 says that, listen to me very carefully. It says that if you could not conduct AGM because of some reason, sir, if the company is not calling for the AGM, then in that case, sir, any person may make an application to the tribunal. Any person can make an application to the tribunal. The tribunal company is not calling for AGM, and in that case tribunal will order the AGM, and in that case tribunal will order the AGM. But listen to me, when tribunal orders such AGM, listen to me very carefully, when tribunal is ordering such AGM, in that order tribunal can write that even if one member or even if one person, one proxy is present, even if one proxy is present, then quorum shall be deemed to be constituted. That is, there is no problem. It will be a valid meeting even if one person or even if one proxy is present. But this can only happen when the tribunal is giving the order. Listen to me very carefully, sir. What was the problem? AGM was not called by the company. So member made an application to the tribunal and tribunal is calling for an AGM. Similarly, sir, if EGM is not called by the company, not AGM. If EGM is not called and it is impracticable to call for an EGM, then the tribunal will order for the calling of an EGM either suo motu or on an application. And it may order that even if one person present in person or proxy, one member present in person or proxy will constitute a valid meeting. So irrespective of quorum, even if one person is coming, it will be valid. So basically 96 and 97 and 98 together, what they are saying, if the company is not able to call AGM or EGM, you inform the tribunal. The tribunal will call for the AGM or EGM. The tribunal will call for the AGM or EGM and it will be a valid AGM, EGM. And more importantly, even if one member is present, in person or in proxy, doesn't matter. Even if one member is present, he can say that it is a valid meeting. Okay, Raja. Okay, sir. Now coming to the next section, what is section number 99? So section number 99 talks about punishment for not calling AGM or tribunal's direction. So basically, if tribunal told you to call the meeting and you did not call the meeting or you did not call the AGM, in that case, the company and officer in default will be liable for a fine which may extend to 1 lakh rupees. And in case of continuing default, further 5,000 rupees per day. 1 lakh rupees fine and 5,000 rupees per day continuous default. Are you with me? 1 lakh rupees and 5,000 per day for every day of default. 5,000 is a big amount, sir. Now coming to the next section, very, very important, section 100, calling of EGM. Guys, listen to me very carefully. I need your 100% attention. For those students who are my class students, you should repeat. You should read from the notes also that we made in the class. Okay. Okay, sir. Sir, section number 100, calling of an extraordinary general meeting. Listen to me very carefully. Sir, what is an extraordinary general meeting? So the meetings other than AGM are all extraordinary general meeting. Now, who can call for an EGM, sir? Sir, either the board of directors can call for an EGM or even the requisitionist can call for an AGM. Either the board of director or the requisitionist. Sir, now listen to me very carefully. When will the board of director call for an EGM? They'll call for an EGM when any time they think fit. Sir, at what time? Say 9 a.m. to 6 p.m. Sir, what place? Sir, they can call at any place in India. They have not written registered office. They said you can call the meeting at any place in India. But however, it has to be in India. You cannot go outside India. It has to be in India. But there is one exception, sir. If your company is a wholly owned subsidiary of a company incorporated outside India, if sir your company is a wholly owned subsidiary of a company incorporated outside India, then in that case, your company can take meeting outside India also. What did I say? Sir, usually you will call the EGM at any place in India. But if your company is a wholly owned subsidiary, partly owned is not allowed, wholly owned subsidiary of a company incorporated outside India, then in that case, you can conduct meeting at any place in India, sorry, any place outside India also. Sir, there is a question on this. There is a very good question on this concept. Okay. Now, but you have to understand this is only for those companies which are subsidiary of a wholly owned company, wholly owned subsidiary of a company incorporated outside India. I think there was a question of Piramal Limited or something. You should solve that. Now, this is how the board can call for an AGM, sir. But what about other people? What if the board doesn't want to call for an AGM? What if the shareholders want to call for an EGM? How will shareholders call for an EGM, sir? Sir, for that, there is a minimum requirement. That if there is only so much of shareholder, they can call for an EGM. What is that minimum requirement, sir? Sir, board shall, at the requisition made by the shareholders, call for an EGM. How many shareholders, sir? If there is a company having share capital, then members holding at least 1/10 of the paid up share capital. 1/10 of paid up share capital. But if company is not having share capital, then at least 1/10 of the total voting power. So there should be at least 1/10 of the paid up share capital or 1/10 of voting power. Only then you can request the board to call for an EGM. How will that happen, sir? Listen to me very carefully, guys. Sir, these are the requisitionists. Listen to me very carefully. Let's scribble. Scribble as in write along with me or try to understand. Sir, this is requisitionist. Requisitionist will send a requisition to the company. Where, sir? At the registered office. Sir, the date is very important. This is the date of receipt of requisition. Date of receipt of requisition. Now, what will happen, sir? Sir, from the date of receipt of requisition, when the requisition is received, first of all, it should be a valid requisition. Valid requisition as in 1/10 of paid up share capital or 1/10 of voting power should be there. Okay. Now, guys, listen to me very carefully. What are these shareholders asking for? These shareholders want an EGM. So, law says that once you receive this requisition, within 21 days, you will have to send a notice for the general meeting. And then within 45 days, you will have to conduct a general meeting. But if you did not send the notice in 21 days, or if you did not conduct the meeting in 14 days, 45 days, then within 3 months, sir, the shareholders, the requisitionist will call for the meeting themselves. They'll call for the meetings themselves. They'll not ask you to call. They'll directly call. But sir, how will they know? How will the requisitionist get to know who are the shareholders? Sir, in that case, if the company could not call for the meeting within 45 days, then in that case, the board of director will share the details of the shareholder, details of shareholder as in name, address, number of shares. These things you will have to share with the requisitionist. Now, requisitionist will prepare a notice of the meeting and then they will share it to all the shareholders. Sir, but what about the cost? What about the money? You'll have to pay some money for sending the notice. So that money will be reimbursed by the company. The company will reimburse such money to the to the requisitionist. And then company will deduct it from the remuneration of the board of director. It will be deducted from the remuneration of the board of director. They will deduct it from the board of director and then they will send it to they'll send it to the requisitionist. Are you with me? Are you with me? Yes or no, sir? Yes or no? Did you understand? Sure. Yes, sir. All right. Perfect, guys. Okay. Now listen to me very carefully, sir. What did I say? I explained the whole process. Try to imagine. Requisitionist went to the company on that date. Company sent notice within 21 days. Company called for the meeting within 45 days. All done. If they could not, then the board of director will share the details with the requisitionist. They will send the notice to all the shareholders and they'll get the amount reimbursed, and then it will be deducted from the board remuneration. But they will have to call for the meeting within 3 months. They'll have to call for the meeting within 3 months. Sir, now let's get into the details. Sir, the requisitionist will have to make a requisition. Requisition is a request in which they'll set out the matters, the signed by the requisitionist, and they'll send it to the registered office of the company. After that, sir, the board will call for the meeting within 21 days of the receipt of requisition, and the meeting has to be called within 45 days from the date of receipt of requisition. So within 21 days, you have to send the notice, and within 45 days, you have to take the meeting. But if you could not, on failure of the board, then requisitionists may themselves call within 3 months from the date of requisition. Within 3 months. However, whatever expenses were there will be reimbursed to the requisitionist by the company, and it will be deducted from the remuneration of the directors. It will be deducted from the salary of the directors. Now, guys, listen to me very carefully. Sir, now, when the requisitionists are calling the meeting, sir, what will be the date? Sir, the date of the meeting will be any day except not national holiday. But where will you call for the meeting, sir? Sir, generally EGM can be held at any place, as in wherever in India you want to. But when requisitionists are calling for the meeting, they will hold it only in the registered office or in the same city town where the registered office is situated. They will not go outside of the city town when requisitionists are calling for EGM. So if someone asks you, where will you hold the EGM? Sir, ideally it can be held in any place in India. If you want to go outside India, then you should be a wholly owned subsidiary of a company incorporated outside India. But however, if the meeting is being called by a requisitionist, then in that case it has to be held in the registered office or in the same city or town village. Now, listen to me very carefully, guys. Sir, after that, please listen to me very carefully. So the board of director will have to share the list of members, their address, and the number of shares with the requisitionist. Okay. Now, how will you send the notice, sir? So the notice will be sent by a speed post, registered post, or electronically. And accidental omission. That is, if you could not send the notice to some person due to mistake, accidentally you could not send the notice, sir, it will not invalidate the meeting. The meeting will be valid. It will not be a problem. Are you with me? Yes, sir. Now the question is, sir, when the requisitionists are asking the company that, boss, please call for an EGM. Sir, are they required to give the reasons for calling an EGM? Sir, they are not required to give the reasons. Are they required to give the reasons? No, sir, they are not required to give the reasons. This was decided in LIC versus Escorts Limited. This was decided in LIC versus Escort Limited. This is your whole section number 100, which talks about EGM. Am I clear? EGM. Am I clear, sir? Yes, sir. Now, moving to the next section, sir, section number 101, which talks about the notice of a meeting. Guys, in order to call for any meeting, you have to send the notice, right? Law says that you have to send notice of at least 21 days notice, and it has to be in writing. It has to be in writing. So this 21 days are clear days. 21 clear days. What is 21 clear days, sir? Clear 21 days means, sir, you exclude the date of service of notice and the date of meeting. Sir, so for example, if I tell you that if I sent you a notice on 31st 31st August 31st August 2025, and I called for the meeting on 22nd September 2025. Sir, how will you count the number of days? Sir, you exclude 31st August. You count from 1st September. So 1, 2, 3, 4, 5, 6, you go till 21. Then you exclude 22 also, because this is the date of meeting. So you exclude the date of service and the date of meeting, and then the gap should be 21 days. So 21 clear days, no confusion. But sir, the question is, if I don't have 21 days, can I send a shorter period notice? Sir, yes, you can send a shorter period notice, but you should have a consent already. Consent of whom, sir? Sir, if it is an AGM, you need consent of 95% of members who are entitled to vote. 95% members who are entitled to vote. But in case of sir EGM, it depends on whether it is a company having share capital or company not having share capital. Sir, in case of company having share capital, you need majority in numbers representing not less than 95% of paid up share capital. Sir, dual limit. You see, there is dual limit. You just don't want 95% of paid up share capital. You want majority in numbers also. Sir, what are you trying to do? You are trying to call for a meeting on a shorter notice. What is shorter notice? That is less than 21 days. Sir, in that case, if it is an AGM, you take consent of 95% of the members who are entitled to vote. So every voting member, 95% of the members. But here it is 95% of paid up share capital and majority in number. There is dual majority. And in case of company not having share capital, you just take 95% of voting power. A very interesting limit, sir. Sir, if these people have given their consent, you can call for a shorter period notice. Shorter period notice. You can call a meeting in a shorter period notice. But guys, listen to me very carefully. The consent has to come first, and then you send shorter period notice. But if, sir, by mistake, if I was supposed to give 21 days notice, but by mistake I gave 19 days notice. Later on, I said, shareholder, I'm sorry, Ray, sorry, is it okay? Shareholder cannot condone the delay. There is no provision for condonation of delay. You cannot say, okay, okay, no problem. No, no, sir. What is condonation for delay? Condonation for delay is basically, uh, for example, if I ask you to submit the test today, if I ask you to submit the test today, if you could not submit it today, tomorrow you'll come to me and say, sir, sorry, this and this happened. So sorry, sir, I could not submit yesterday. Please take my test papers, sir. So I'll take it. That is condonation for delay. I forgave you for your mistake. But now, in case of shorter period notice, if the approval was not taken first, later on the delay cannot be condoned. There was an exam question on this, sir. Okay. Now listen to me very carefully, sir. To whom will you send the notice? Sir, the notice will be sent to every member, to all the through the auditor of the company, to directors of the company. So it will basically send it to mad people, member, auditor, and director. But however, in case of death of the member, you will send it to the legal representative. And if the member have become insolvent, you'll send it to his assignee. Whosoever is the assignee, you will send it to them. So member, auditor, and director. So mad people. I say mad people as in member, auditor, director. Now, guys, listen to me very carefully. Accidental omission will not invalidate proceeding. If by mistake you could not send the notice to any specific person, it will not invalidate the proceeding. The proceeding will be still very much valid. Are you with me, guys? Yes, sir. Sir, are you with me? Sure. Yes, sir. Perfect. Okay. Okay, sir. Now listen to me very carefully, guys. Please. Sir, this is your sending of the notice. Now, how will you send the notice, sir? The question is, can you send the notice via an electronic mode? Can you send the notice through an electronic mode? Law says, yes, sir, it is a statutorily recognized mode. That via email, if you want to send, it is statutorily recognized. That is, it is legally allowed. It is legally allowed to send notice through a electronic mode. Then after that, please understand, when you send the notice, it can be sent as a text, attachment, or a URL. It can be a text, attachment, or a URL. The notice can be sent in the form of a text, attachment, or URL. I call it as TOW. TOW, text, attachment, or URL. After that, listen to me very carefully. So the email has to be addressed to the entitled person, and the company will allow you to change or add the email at least once in a financial year. You have to write these 4 points. You have to write these 4 points. If someone asks you, can you send a notice via email? Don't say yes. Say that yes, we can send a notice via email. It is a statutorily recognized mode. Number two, it can be sent in the format of a text, attachment, or URL. Number three, it has to be addressed to an entitled person, the person who is entitled to receive it. And number four, you will allow, the company has to allow adding the name or changing the name at least once in a financial year. If all these four conditions are satisfied, only then we will allow you to send via email. Okay, sir. Sir, a few questions. Listen to me. Sir, can an individual director call for a general meeting? Who will call for a general meeting, sir? Sir, one director cannot call. The board of directors, as in all the directors have to together decide. One director cannot decide. Is it okay, sir? Yes, sir. Sir, number two, company's obligation to send notice shall be satisfied when it transmits the email. Company cannot be held responsible for the transmission of email beyond control. For example, sir, I sent you an email. but you did not receive that email. You cannot shout at me saying, Arey, you didn't send the email. Arey boss, I sent the email. My responsibility is only to ensure that I properly send it. Now it is not coming to your box. That is your problem. That is not my problem. Okay. Okay, sir. Now please understand that, sir. That is more or less. Now coming to the next section. Section number 102, very important, very important. Please listen to me very carefully. Sir, what is section 102? We'll keep it a very short session. We are going to read anyway till section 105. So we'll keep it a short session, but listen to me along with, keep listening to me. Okay. Okay. Guys, sir, what is section 102? Section 102 talks about explanatory statement. Explanatory statement as in, please try to understand. In your Companies Act, there are two kinds of business. One is ordinary business and one is special business. Sir, what is ordinary business? Hello. Sir, what is ordinary business and what is special business? So I'll tell you. In special business, if we talk about special business, listen to me. I'll tell you first what is ordinary business. Sir, in the AGM, when you do these four things, it is ordinary business. What four things, sir? Number one, consideration of financial statement and approval thereof. Consideration of financial statement and approval thereof. Declaration of dividend. Appointment of director in place of retiring director. Appointment of director in place of retiring director. And number four, appointment and fixing remuneration of auditor. So when you're talking about remuneration, you're only talking for auditors. But for directors, we are not talking about remuneration. We are talking only about appointment of directors in place of retiring directors. So guys, four business, your consideration of financial statement, declaration of dividend, appointing of director in place of retiring director, and appointment and fixing remuneration thereof. All these four business are special business. Sorry, ordinary business in an AGM. In AGM, when you do these four things, it is ordinary business. But apart from that, every other business is a special business. Sir, anything that you do in EGM, anything and everything, that is all special business. Why, sir? Sir, it cannot be ordinary business. The name of the meeting is Extraordinary General Meeting. Every business there is a special business. So, ordinary businesses in AGM, when you do these four things, it is ordinary business. In AGM, other things are special business. And in EGM, everything is special business. I've summarized it here. You can see, sir, for AGM, these four things are ordinary business. Other things are special business. In EGM, there is no special ordinary business. Everything is a special business. Now, what is the point, sir? What is the point? The point is, sir, if you are sending a notice and in that there are some special business, sir, you will have to attach explanatory statement. Come on, repeat with me. What will you attach? You will attach an explanatory statement. What is the purpose of that explanatory statement, sir? In that, you will say two things. Number one, sir, in that explanatory statement, number one, you will show the nature of interest, whether financial or otherwise, of each items of director, manager, key managerial person, or relative. So, for example, if you are entering into a transaction, you have to show whether your director, key managerial person, or their relatives are interested in such transaction. You'll have to disclose their interest. And number two, you will state any other information or fact that is relevant for decision making. So you'll give more and more details, sir. You will disclose other facts and information which is relevant for decision making. So two things. You will disclose your financial or other interests, yours as in your manager, director, key managerial person, or their relatives. And you will disclose any other information which is relevant for decision making. What do you mean, sir? So for example, if I want to issue a right shares, I want to issue right shares. So I have to tell you, right, that I'm issuing one share for one right share for one share or 5:1. What is the ratio? I have to tell you, right? If I don't tell you that, can you make a decision? No, sir. So I have to give you all the information or facts that will help you understand the resolution and take a decision. Okay. These are the two things that I have to do. But listen to me very carefully. Sir, what if I did not disclose the first one? If I was to disclose the interest of my director, manager, key managerial person, but I did not disclose it. I chose to stay silent. In that case, sir, if any benefit accrues to the promoter, director, manager, key managerial person, or their relatives, if anyone is getting a benefit out of that, sir, they will hold such benefit in the trust of the company. That is, they will have to give that benefit back to the company and they'll be liable to compensate the company to the extent of such benefit. That is, they will hold it in the trust of the company and they'll have to give that money back to the company because that benefit is of the company, sir. I've given you a lot of examples in the class, Raja. This is a revision in our classes. We discuss this completely, that what is each and every point we discuss, right? You know that, correct? So now what I'm telling you is in section 102, there is ordinary business, there is special business. What is ordinary business? In AGM, in AGM, in AGM, when you do these four things, one, you consideration of financial statement, declaration of dividend, appointment of director in place of retiring director, appointment of auditor, and fixing remuneration thereof. These four business in an AGM is considered as ordinary business. Apart from that, everything else in AGM or everything in EGM is special business. For special business, you have to do two things. One, disclose your interest, financially or otherwise. And number two, you give all the information. But if you did not disclose your interest, then if any benefit got accrued to the promoter or the director or the key management person, then they will hold it in the trust of the company and they'll have to compensate it to the company. They'll have to compensate it to the company. Okay. One extra point, sir, listen to me very carefully. That one extra point is, sir, in case of special business, if there is a special business that is going on between two company, one company and the other company, sir, where there is a special business with other company, then and the shareholding of your promoter, director, manager, or the key managerial person is not less than 2% of paid up share capital. Sir, if there is a transaction between B Limited and A Limited, and the promoter, director, key managerial person, etc., they are holding more than 2% of paid up share capital, more than equal to, then in that case they will have to disclose that also, sir. They shall be set out in the explanatory statement. You will have to disclose those things also. You'll have to disclose shareholding also. This is a special disclosure, sir. This is specifically saying only if the shareholding is more than equal to 2%. More than, it is not less than 2%, it means it is equal to 2% or more than 2%. In that case, this provision applies. This is your section 102. Did you understand, sir? Did you understand? Yes, perfect. Okay, sir. Now coming to the next very, very, very important section, which is your section 103, which talks about quorum. Which rum? Quorum. Quorum, what is quorum, sir? Quorum is the minimum number of members which are required to be present in a meeting in person present in a meeting for to make the meeting a valid meeting. To make the meeting a valid meeting. So what is quorum, sir? Listen to me very carefully. Sir, unless article provides for a larger number, that is quorum, articles can give you a larger number. But unless that happens, what is the quorum? In case of a public company, the quorum is up to 1000 members, 5 members personally present. More than 1000, but up to 5000 members, 15 members personally present. More than 5000 members will be 30 members personally present. So basically, quorum is in case of a public company, not more than 1000 members, then 5, 15, 30 members personally present. That is, you count those members who have actually come. You will not count those members who are proxy. Proxy will not be counted. You'll only count those members which are personally present in case of a public company. But in private company, we said only 2 members personally present will be considered as quorum. Okay, guys, now listen to me very carefully. Guys, please listen to me very carefully. Sir, when you call for a meeting, hello, sir, listen to me very carefully. When you call for a meeting, let's say I called for the meeting at 10 o'clock, 10 a.m. in the morning. Sir, the quorum has to be checked within 30 minutes. After 30 minutes, you'll have to check the quorum. Sir, if the quorum is present, as in the minimum numbers of members are present, then it will be a valid meeting, no problem, sir. But sir, if the quorum is absent, then in that case, sir, usually what will happen? The meeting will be adjourned. The meeting will be adjourned. That is postponed to a next date. But sir, if the meeting was called by requisitionist, if the requisitionist has called the meeting under section 100, if it was an EGM called by the requisitionist, it will not adjourn, sir. It will get cancelled. It will get cancelled. They'll cancel it. They'll not adjourn it. But otherwise, if the quorum is not present within the 30 minutes, that is, even 5 members were not personally present. Or in case of private company, if even 2 members were not personally present, you will adjourn the meeting, sir. Adjourn as in to a later date. Now, what will be the later date, sir? Sir, the later date will be same time, same place, same day, next week. Everything will be same, just that next week. So instead of today, as in Wednesday, you'll go to the next Wednesday. Same time, same place, same day, everything will be same. Date will be different. So it will be adjourned next week. Now the question is, sir, but what if you don't want to adjourn it to next week? You want to say, no, no, not next week. We'll do it after 2 months. Okay, sir, you can do that also. So basically, you can adjourn to the next week also or to such date as the board may decide. But sir, now, will you give the notice for an adjourned meeting? Do you have to give the notice for an adjourned meeting? We said, see, boss, notice is generally sent 21 days before the meeting. So it is not possible to send the notice here, but at least before the meeting, 3 days before that, either we will inform each one of them individually, like one by one, we will inform them, all the shareholders, or we will give an ad in the newspaper that, boss, after 3 days, we have our adjourned meeting, you should come. Okay, so basically, at least 3 days before, you inform individually or through the newspaper. So what did I say, sir? Let's try to understand. Please try to understand again. What did I say, sir? You have to check within half an hour quorum. Now, if quorum is not present within half an hour, the requisitioners meeting will stand cancelled. But however, other meetings will either be adjourned to next week or such other date as the board may decide. Board can also decide that I don't want next week, I want at a later date. But sir, however, in case of adjourned meeting, the company will give 3 days notice to the member either individually or you publish it in the newspaper, two newspapers, sir, always English newspaper and vernacular newspaper. Sir, what if shareholders are not present in the adjourned meeting also? Once you called for the meeting, quorum did not come. You adjourned it. In adjourned meeting also members are not present. In that case, sir, the members present will be deemed to be quorum. That is, for example, if my company had 900 members. Sir, what is the quorum for me? Quorum is 5 members. I called for the meeting, only 3 members came. So I could not conduct the meeting. I adjourned it to next day, to the next week. In adjourned meeting also, sir, only 4 members came. What was the quorum, sir? The quorum was 5, but 5 did not come. No problem, sir. Members present will be deemed to be quorum. But at least there should be one member. Huh? At least there should be 2 members. Huh? One member cannot be a quorum. There should be at least 2 members. Sir, can one member ever constitute quorum? Can one member ever constitute quorum? Yes, sir. In section 97 and 98, do you remember when tribunal calls for a meeting? Tribunal can get angry and say, hello, hello, one person is coming. Okay, valid meeting. So tribunal can do that, but apart from that, one member cannot constitute a quorum. Are you with me? Are you with me? Yes, sir. Now listen to me very carefully, sir. When you are studying about quorum, one thing is very carefully written that members should be personally present. What do you mean by members personally present? How can they be present otherwise? Sir, when you're saying personally present means, are you saying they should not be there in video conferencing? No, 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 no. When we are saying personally present means we are saying you proxy will not be counted. What is proxy, sir? Proxy is that instead of you going to the meeting directly, you send someone else on your instead of you going directly, you send someone else on your behalf. So proxy, what is proxy, sir? If listen to me, if I am a shareholder of Reliance, okay. And if I can attend the meeting and I can vote in the meeting. If I have the right to attend in the meeting and vote in the meeting, then I have the right to appoint a proxy on my behalf who will go and attend and vote at the meeting. Proxy on my behalf who will go and attend and vote at the meeting. So basically come to section 105, which talks about proxies. Guys, any member who is entitled to attend and vote may appoint any other person to vote on his behalf. But please understand, sir, proxy will never vote in case of show of hands. In show of hands, proxy will not vote. Proxy only votes when it is a case of poll. Whenever it is a case of poll, proxy becomes very active. Even do you know that proxy can even demand for poll? Proxy can say, no, no, show of hands is not okay with me. You please do a poll. This can be demanded by a proxy. But listen to me, proxy has no right to speak in the meeting. He cannot speak in the meeting, but he can only vote on a poll. When there is a poll voting, he can vote on that. But sir, the question is, if I want to become a proxy, can I become a proxy? Yes, sir. For how many members can I become a proxy? Law says that you can become a proxy. Listen to me very carefully. You can become a proxy for 50 members, 50 members, and their total should not exceed 10% of share capital voting rights. Sir, you can become a proxy for maximum 50 members holding maximum 10% of voting power. So if you are going as a proxy, you can become proxy for up to 50 members or up to 10% of voting power, not beyond that. But sir, what if there is one person who has 15% voting power? For example, Mukesh Ambani holds 51% of Reliance, for example. He wants to appoint a proxy. How will he appoint, sir? Because you said you can become proxy for maximum 50 members or maximum 10% of voting power. Sir, in that case, if a single member is holding more than 10, you can become proxy for that member, but then you cannot become proxy for any other member. You can become proxy only for Mukesh Ambani, not for anyone else. Okay. So please understand, you cannot have too much of power. You cannot have more than 10% voting power. So basically up to 50 members having 10% of voting power. But in case if single member has more than 10%, you can become proxy, but you cannot become proxy to any other members. You cannot become proxy to any other members. Sir, I have a question. If Reliance has two shareholders, shareholder A, shareholder B, B doesn't want to go. B wants to appoint someone as proxy. Is it necessary that he appoints a shareholder only, or can he appoint any person as his proxy? Law says that, sir, in case of a company, you can appoint any person as your proxy. Even if he is a shareholder or not, it does not matter. You can appoint any person as a proxy. But sir, in case of a Section 8 company, only members can become proxy. Other people cannot become proxy. So if B wants to find a proxy, he will have to approach A. He cannot send some random person to the meeting of a Section 8 company. And all these things that I'm telling you will be written in the notice of the meeting, sir. You know what will be written in the notice of the meeting? Sir, when you get a notice of the meeting, number one, they will tell that you as a shareholder, you have the right to appoint a proxy who will attend on your behalf and vote on your behalf. Number two, you will write that the proxy need not be a member of the company. It is not mandatory that proxy is a member of the company. It can be any person. But Section 8 company cannot write this line, sir. Because in Section 8 company, only a member can be proxy. Are you getting my point? Guys, are you getting my point? Yes, sir. Sir, what after that? Listen to me very carefully. Sir, now there are two things. If you want to become a proxy, if you want to become a proxy, there are two things. One, you have to submit a proxy form. And number two, you can do inspection. One, you have to submit a proxy form. And number two, you can do an inspection. Sir, what do you mean by submission of proxy form? Listen to me very carefully. Sir, submission of proxy form means that you will have to sign a form called SH11. SH11? No, sir, management and administration. So you will have to take a form MGT11. In that MGT11, you will fill the details of the proxy and you will have to submit it to the company at least 48 hours before the general meeting. At least 48 hours before the general meeting. And trust me, this 48 hours timeline cannot be made 24 hours. It cannot be made 72 hours. It is fixed. You will have to submit the proxy form at least 48 hours before the general meeting, and only then your valid proxy form is valid. Now, if someone submits it before 48 hours, it is valid. If someone submits it after 48 hours, it is not a valid form. So, for example, if the meeting is on 15th October 2025, you'll have to submit at least a morning 10 a.m. You'll have to submit it by 13th October 25 morning 10 a.m. If you submit after that, it will not be valid. So now tell me, if someone wants to inspect this form, if you submitted a proxy form and I want to inspect it, can I inspect it? Sir, law says that you can do the inspection, but you will have to send a notice for the inspection. Notice for the inspection. You will have to send a notice for the inspection, and that notice for inspection has to be sent at least 3 days before the general meeting. At least 3 days before that, you will have to inform the company that, hello, I want to inspect the inspection for, I want to inspect the proxy forms. And then when can you inspect, sir? Sir, starting 24 hours before the general meeting, 24 hours before the general meeting, till the end of general meeting, you can inspect during business hours. You can inspect during business hours. Sir, so what did I tell you? There are certain time limits that you need to remember. Here you go. Sir, this is the start of general meeting and this is the end of general meeting. Okay. Sir, 48 hours before. Okay. You have to submit form MGT11. If you want to inspect 3 days before, you'll have to give a notice for inspection that I want to inspect. And when can you inspect? So starting from 24 hours before the general meeting till the end of general meeting, during business hours, you can go and inspect that proxy form. So this is the time limit that you have to understand. Proxy form has to be submitted 48 hours before, but if you have to inspect it, you have to send a notice 3 days before. But inspection can be done 24 hours before the start of the general meeting till the end of general meeting. Okay, so these are the time limits that you have to be absolutely careful about, and that is your section 105, which talks about proxy. Now, listen to me very carefully. When proxies attend the general meeting, you don't count them for quorum. Proxies are not counted for quorum. Only members who are personally present will be counted for the purpose of quorum. Now, to give a closure to this topic, sir, we have to also read section 115 and 116 along with 114 and 112 and 113 along with it. Look at my screen. Sir, what is 112 and 113? Sir, 112 says that representative of president or governor. Sir, in my company, central government and state government could be the shareholders. If central government is the shareholder, it is held in the name of president. If state government is the shareholder, it is held in the name of governor. Now, president and governor, they will not come to my meeting directly. So they will send a representative. Sir, that representative is considered as a member, not a proxy. He has all the rights as that of a member. So that means that he has all the rights of that of a member, means that when representative attends the general meeting, he will be counted for quorum. Proxies are not counted, but representative will be counted. Moreover, if representative wants to appoint a proxy, they can do it because representative are treated as a member. You just have to read this line. They will be deemed to be a member of the company. They will have to have a right to vote, and they can also appoint a proxy. So basically, representative are as good as members, not as bad as proxy. And similarly, sir, even companies can send representative. Even companies can send representative because companies cannot come themselves. Those representative will also be treated as members. But listen to me very carefully. If I myself, Shubham Singhal, if Reliance appointed me as a representative and Adani also appointed me as a representative, then in that case, I will be counted as two members for the purpose of quorum. You didn't listen to me. Now listen to me very carefully. If I am coming to the meeting of Tata, Reliance is the shareholder, Adani is also a shareholder. Reliance appointed me as a representative. Adani also appointed me as a representative. So I'm representing two companies, Reliance and Adani. So now I will be counted as two members and not one member. So for quorum, I will be counted as two. If you have understood this clearly, now solve this question along with me, sir. Sir, A Limited is a company having 1200 members. Evaluate the quorum is present or not. So for 1200 members, the quorum is 15 members personally present. Yes or no? Yes, sir. Now let's see how many members are present. A, B, C are shareholders of A Limited, 3 members. D and E are joint shareholder. So joint shareholders will be counted as 1. Okay. F, G and H are preference shareholder. Sir, only for those decisions where preference shareholder can vote. Only for those resolutions you will count preference shareholders, but otherwise you will not count. So we'll take it as no. We'll think that there is no voting for preference shareholder. Next, Y and Z are X and Y are proxies. No, sir, we don't count proxies. P is a representative president. Okay, one. G is a representative governor. Okay, one. H is a representative of body corporate. Okay, one. M is a representative of body corporate 3 and body corporate 4. Okay. 2. It will be counted as 2. So 2, 3, 4, 5, 6, 7, 8, 9. So total 9 members. Quorum is not met. Quorum is not met because your members are not present. Okay. Now next question, sir. Listen to me very carefully. Sir, you check quorum at the start of the meeting, right? Within 30 minutes. Okay. Quorum was present. Now will you check quorum throughout the meeting or just at the start? Should quorum be present throughout the meeting or just at the start? Sir, quorum should be present throughout the meeting. Throughout the meeting, quorum should be present. Just at the start is not enough. Quorum should be present throughout the meeting. Only then the meeting will be valid. If the quorum becomes absent, then all the resolutions taken after that will be invalid. The resolutions taken after that will become, all of them will become invalid. Are you with me? Did you understand, sir? Yes, sir. Sir, this is your section number 112 and 113. Now, coming back, we will have to do 104, 106, and then I'll end the session. Sir, what is section 104? Very small section, sir. Nothing important. Chairman of a meeting. Please listen to me very carefully. How do you appoint the chairman of a meeting? So, the first thing is AOA. In AOA, you can clearly write who is the chairman. For example, in Reliance, it is clearly written that Mukesh Ambani will be the chairman of a meeting, of general meeting. We are talking about general meeting here. But sir, if they have not written anything, then the members personally present will select by show of hands. How will they select? By show of hands. They'll select someone to be a chairman. But however, sir, in that, while you're doing that, poll may be demanded. So you are trying to vote by show of hands, but someone said, no, 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 we want to do a poll. So poll may be demanded. Now, if poll is demanded, then who will conduct the poll, sir? So, for example, by show of hands, you appointed Mr. Ram as the chairman. Okay. Now, someone demanded for the poll. Who will conduct the poll, sir? Sir, Mr. Ram will conduct the poll. Until the end of the poll, Mr. Ram will be the chairman. Now, after the poll results are out, if, for example, Mr. Sham gets appointed, Mr. Sham will be the chairman. So basically, if poll is demanded on an election of chairman, chairman elected under subsection 1, that is chairman elected by show of hands, will continue to be chairman until some other person is elected as chairman. And such other person shall continue for the rest of the meeting. Okay. Sir, what is the role of the chairman? Sir, the role of the chairman is to maintain decorum of the meeting. They'll ensure that there is a decorum in the meeting. And the very important role is if AOA allows, if article of association allows, then the chairman will have a second vote or casting vote. What is second vote or casting vote, sir? Second vote or casting vote means that, for example, if there is a tie, as in 5 people voted in favor, 5 people voted against such resolution. 10 people voted, 5 in favor, 5 in against. It's a tie. Now, who will bring you out of that tie? Chairman. Chairman will get a second chance. Chairman will vote again and chairman vote will be counted. He'll get a casting vote. This is your section number 104, which says that chairman will be appointed by show of hands or poll may be demanded. Okay. Now, that brings us to next section, section 106. And the last section for today. Sir, 106 talks about restriction on voting rights. There are questions on this section. Sir, you remember that equity shareholder can vote on all the resolutions and preference shareholder can vote on only those resolutions that affect them or resolutions related to winding up, etc., etc. Correct? Now, the question is, sir, you said that voting. Okay, you said about voting. Now, listen to me very carefully. Sir, now the question is, can you stop someone? Can you tell a member, hey, you cannot vote? Law says that yes. Sir, law says that AOA may provide for AOA. If AOA allows you this power, then you can restrict the voting right of person whose call is unpaid or where the company has exercised any right of lien. If the call is unpaid, if there is some unpaid calls in arrears, or if the company has exercised right of lien on their shares, in these two cases, if AOA allows you, then you can restrict their voting rights. You'll say that no, boss, you cannot vote until you make the full payment. But apart from that, there is no reason where you can restrict the voting right. Except for the above, a company shall not prohibit voting rights. Sir, in case of poll, members are entitled to more than one vote, need not use all its vote or cast it in the same way. It means what, sir? Sir, if I have 100 votes, I can decide to vote in favor for only 80 votes and remaining 20 votes, I may not use it. Or it may be possible that votes against can be 20 votes. I can say that 20 votes are against such resolution, for 80 are in favor. Although it is nonsense, but I get to choose, sir. Each and every vote. It is not 100 vote. It is 100 different votes. I can use it the way I want. Okay. Now, what if it is a case of joint shareholders, sir? How to joint shareholder decide? Sir, ideally speaking, joint shareholder must concur. As in they should agree with each other. But if they do not agree with each other, we will go in the order of seniority. That is the person whose name appears in the name appears first in register of member. He is a senior shareholder, and his decision will be taken. His decision will be considered. So whenever there are joint shareholders, they should agree with each other. But if they do not agree with each other, no problem. We'll take it in the order of seniority. Okay. So this was your section number 106. Now that's it for today. We will continue it in the second half. Tomorrow we are going to continue the voting process and then maybe we'll have a third session also. We'll decide that tomorrow. Okay, guys, we'll keep it very short. We'll keep it very quick so that it is very convenient for you to watch and understand. But before I end this session, I want to tell you one thing that, guys, uh, it takes a lot of effort to make sure that everything that you're already doing, you're separately doing it in full English just for the benefit of those students who do not understand Hindi, right? So if at all these sessions are helpful for you, it would really mean a lot to me if you could just spare some time to like this video, to share it with all your friends, and to let me know in the comment whether you appreciate this effort. And you keep doing that for all the videos, because the more effort, the more appreciation I get, the more I stay motivated to put such videos for you, right? So I can bring more and more videos for you, but only if I know that it is becoming very helpful for you. So do let me know in the comment whether it is helpful for you. And we will continue this in the next session. Until then, you keep studying well, keep putting a lot of efforts. This attempt is going to be a golden attempt for you, and you're going to rock it. But for that to happen, you have to give your 100%, you have to give your best. And please do not shy away from doing hard work, because there is no substitute for hard work. The more hard work you do, the more successful you get. All right, guys. I hope this session was helpful for you. I hope you enjoyed this. I'll see you in the next session. Until then, please take care, study well, keep going. This is your CA buddy Shubham Singhal signing off. Bye bye.